Okay, now we're going to talk about negligence. Negligence is a tort, probably the tort that causes more litigation than any other. And negligence is an unintentional tort. To be successful in a negligence lawsuit, the plaintiff must prove either 4 elements with 2 subparts or 5 elements. But, number 1, there is a duty of care to the plaintiff. There has to be a duty owed to the plaintiff by the defendant. The defendant breached the duty of care. Because of that breach, the plaintiff suffered injury. The defendant's negligent act caused the plaintiff's injury. These are the 4 primary elements with the 2 subparts. The causation was actual cause or proximate cause. I actually learned it as 5 elements of duty, breach of duty, injury, actual cause, and proximate cause. But you can do 4 with the 2 subparts if you want. Okay, so what do we mean by duty? Well, when does somebody owe a duty to somebody else? Some of these duties are automatic. Reasonable person test. Merchants for safety of their premises. These are the banana slip and fall in the grocery stores. Grocery stores owe a duty to have their floors clean and safe for their patrons as they walk through. Lifeguards obviously owe a duty to take care of the people on the beach or the swimming pool. Look at Linnelli versus Burger King, case 10.3 on page 295. This is an interesting case because the lower court actually found that Burger King was not liable because it did not owe a duty. We're going to see in a few minutes that intervening acts can alleviate the plaintiff from their duty, and criminal activity is usually considered a intervening action. But in the Linnelli case, we find that there was criminal activity in the form of a gang or teenagers, rambunctious, whatever. Anyway, the patron was assaulted on the premises of Burger King. Normally, an assault like that is not the responsibility of the proprietor or the owner of the premises. However, in the Burger King, we see that the court held that there was a foreseeability of the action taking place. The court in the Burger King case cited another case, Walls v. Oxford Management, where they held that as a general principle, landlords have no duty to protect tenants from criminal attacks. However, they recognized in Walls that there could be particular circumstances that give rise to such a duty, and that is when the foreseeability of the criminal action exists. And the Burger King case goes on to indicate how the employees and the manager could see what was happening, and it was reasonably foreseeable that the consequences would be. And at that point, they had a duty to take some action. Some duties are assumed by the defendant. When a defendant undertakes the action that she's not required to do, she assumes the consequences. So if you are in a situation and you step up and start taking action, by doing so you would be assuming the duty that would not otherwise be required of you. If the malpractice is the negligent action of professionals, such as doctors, lawyers, architects, they owe a duty of ordinary care relative to their profession, called the reasonable professional standard. So a doctor is held to a higher standard when they are treating a patient than would be a normal person. They have additional training. They've assumed that duty. However, when the doctor is driving a car, they obviously have no higher duty than anyone else who would be a driver. A professional who breaches this reasonable professional standard is liable for malpractice. So malpractice is a negligence cause of action. Okay, causation. Causation in fact. The defendant's negligent act must be the cause that caused the plaintiff's injuries. It is the but for. But for the action of the defendant, the plaintiff would not have been injured. This is direct causation. Proximate cause is the second subpart or the 5th element of negligence. Proximate cause is talking about the foreseeability of an action. up to a point along the chain of events caused by the negligent party, there is foreseeable. There comes a point when it is no longer legal, the defendant is no longer legally responsible for the consequences of his or her actions. And this is something that the jury is to determine. And remember, when you look at this and you look on the front end before the action, you say, well, that's not foreseeable that that would happen. Remember, the jury is always Monday morning quarterbacking. They're looking at the facts after they happened and somebody was injured. And there's a real tendency for the juries to look at it and say, well, if they were injured, it was obviously foreseeable that they would be injured. So most of the cases find this causal connections and will hold the plaintiff liable, especially if it's a deep pocket or business or something like that that is being held liable. Look at the case of Palsgraf versus Long Island Railroad on 10.9, page 300. This is actually a very well-known case, and it goes into the foreseeable issue. Did defendant owe Palsgraf a duty? Well, of course. The defendant was Long Island Railroad, and they had passengers coming into their railroad station, and they did owe them a duty to make sure that that station was safe. Were there damages? Well, yes, the woman was injured. The weight fell on her, and she was injured. Did it breach that duty? The risk reasonably perceived defines the duty to be obeyed. Did the plaintiff cause the accident? But for the railroad's action, would Palsgraf be hurt? Yes, it was a conductor that grabbed the package out of the other person's hand. The package fell, the fireworks went off, and because of that, the woman was injured. So there was clearly a cause. But was it foreseeable that the conductor's action by pushing a passenger into a train that Palsgraf 30 feet away would be injured? The court said there had to be proof of more than proof of negligence in the air. They said proof of negligence in the air, so to speak, will not do. The railroad was not the proximate cause of her injuries. By the way, it took 7 years for this case to wind its way through. A very interesting case. It is located at 162nd Northeast 99. It's a 1928 case, but is one that set the standard for foreseeability for many years. So, was the accident reasonably foreseeable is what the court will, or the jury is always to determine. Can GM be sued by a pickup truck owner when the pickup truck's engine fails and the pickup pulls off the side of the freeway and then struck by another car? Did GM know that this specific truck was going to, the engine would stall and would be hit by another car on a Saturday afternoon on the 405 freeway? No, they didn't know that. But foreseeability goes to the general action, not to the specific event. Is it foreseeable that if an engine fails, that a truck would be pulled on the side of the road and another car might hit it? Well, most juries will find that that is foreseeable. That's a logical consequence if you have to pull a truck to the side of the road. To look at this, see Fisher v. Pepsi-Cola Company. It's on Moodle. Was it foreseeable that the specific dispensing machine would have a short circuit? No. But it was foreseeable if it did have a short circuit that a person would be injured. Does the defendant or the plaintiff have to show the specific type of injury? No. It just have to show that it would be foreseeable that a similar injury or an injury like that would in fact be occurring. Okay, what are the defenses for negligence? There are certain affirmative defenses. These are defenses that the defendant can come by and say that they were not liable because, and they actually make these as specific allegations in their answer to the lawsuit. Contributory negligence. They're saying that the plaintiff was at fault. This is also contributory and comparative negligence. We'll talk about that in a minute. And the assumption of the risk. Plaintiff knowing and willingly undertaking the risk. There is also a defense of superseding or intervening event. This is really a proximate cause defense, saying that there were unforeseeable actions, or things were so far removed from the cause that they were superseding and they intervened in the liability. They no longer allow the defendant to be liable. Lightning striking an unconscious golfer. Illegal acts are usually superseding or intervening events. The individuals are not responsible for illegal acts that take place. But there is a wealth of cases and a large line of cases that hold that if the illegal act itself is foreseeable, the plaintiff will still be held liable. That's what we talked about in the Burger King case. Contributory negligence. Some states still have this. Most have comparative negligence. But contributory negligence says that if a plaintiff contributed to the negligence at all, then they cannot collect any damages. Some cases have felt that this was far too stringent, that a person was a minor, contributed to the action, and therefore they didn't get anything. Some states required that the condition be more than 50% contribution. But there is the last clear chance rule. Don't hit a jaywalker. In other words, just because a person is contributing to the accident by walking across the middle of the street, you still have the obligation to the last clear chance to avoid hitting that person. Comparative negligence, and this is Yee versus Yellow Cab, which is one of the cases to be briefed this week. Many states have changed the standard from contributory to comparative, and here they allocate the damages between each party. So they look at the action, they see that there was negligence, they see there's $100,000 of damage, injury to the party. They were 20% comparative negligence. They were jaywalking or they were careless. And then they'd say out of the $100,000, $80,000 is to be paid by the defendant and 20% is borne by the plaintiff. So that gives the example of comparative negligence. Attorneys have figured this out. They wait to send signals to juries, and many times it seems that juries end up making larger awards, damage awards, so that the plaintiff will get more. Assumption of the risk, fascinating defense. The plaintiff assumed the risk of that activity. The plaintiff knew the risk and voluntarily assumed it. Typical of sporting events such as mechanical bulls. Look at the Knight v. Jewett touch football game. She assumed the risk of being injured when she started playing the touch football. However, be careful. Assumption of the risk only covers the expected risk, i.e. skiing, but not a ski lift accident. People go to ski lifts, ski resorts. They know they may have an accident on the ski run, running into a tree, or somebody may run into them, but they do not expect, and that's an assumption of the risk issue, they do not expect the lift to break and drop them on the ground, or what I heard when I was in Big Sky a couple of years ago, a man left on the ski lift all night long and died of exposure, froze to death basically. That was not one of the expected risks that a person had when they went to skiing. So it only covers the expected risks that they knew of. Okay, I'm going to do a part C on chapter 10 because it's such an important chapter, and that will be on strict product liability. Thank you.